All right, so for a deeper dive, let's welcome back to dissect it all for us, trial attorney and legal analyst Richard Schoenstein. Richard, great to see you again. All right, so I was just speaking with you earlier this week. What do you now make of this abrupt reversal by Mangione's lawyer, essentially a day after we had learned they were considering using that psychiatric defense?
Well, I'd say two things about it, Nichole. First of all, it's not so abrupt because apparently they gave the initial notice that they might go this route back in September of 2025. This has been in play for 9 months, although much of it has been sealed, so we didn't know about it. It's not really abrupt. But when pressed on it at that conference in early June that was also under seal, the defense revealed that their psychiatric examination had not yet been concluded. And the judge was pressing them. You need to turn over the records. You need to turn over the name of your expert witness, the biography of your expert witness, if you're going to pursue this evidence at trial. And when they withdrew the notice yesterday, they didn't necessarily withdraw the defense. They withdrew the notice that they were going to use psychiatric expert testimony. They withdrew evidence. They didn't necessarily say they're not going to argue this at trial.
Interesting. All right, so we know that Mangione would have avoided the charge of second-degree murder if he were to successfully convince a jury that strong emotions led to that profound loss of self-control. So again, now you just added another caveat here, but do you think the defense would be taking a big risk, since that means that charge would now be back on the table?
Wait, listen, there's so much at play here. There are so many strategy decisions to be made. You don't just have one trial, you have two. And part of the problem with using extreme emotional disturbance in state court is you are essentially conceding guilt. And in federal court, there is no extreme emotional disturbance defense. So now you've conceded guilt, and you might end up at a second trial in federal court where you've already conceded guilt. So they had to consider that. They had to consider the expert report that they were preparing. I don't know what that looked like. Maybe they didn't think it was strong enough. Maybe they didn't want to hand over all of that medical evidence, and maybe they didn't want to make their client available for an examination by the state, which the state would have had a right to do if they were pursuing the evidence. Maybe they didn't like the public reaction when it was disclosed that Mangione might use this defense. It could be any or all of those factors playing into the decision-making here.
All right, so we just heard a lot of maybes in that answer there from you. But I'm highlighting that because due to this new withdrawal, the judge now put the documents and transcript that had exposed the defense strategy. It is now back under seal. So because, you said all of those maybe, are we going to have to wait till the trial to now fully know the defense's strategy?
I think so. That's not that uncommon. You usually wait to the trial to know what the defense is going to do. Sometimes the defense doesn't fully know what it's going to do until it hears the prosecution's case. The defense has every right to just sit there while the prosecution tries to put on its evidence of proof of guilt beyond a reasonable doubt. And at the end of that evidence, the defense can just say, we don't have a case. We don't think you've put on enough evidence. We're going to argue reasonable doubt. Or the defense can put on evidence and make a different argument. We're not really going to know until the trial exactly what they're arguing to that jury.
So, Richard, we just heard there from Marcus Espinoza. At the end of his report, he highlighted all of the delays that we've already seen, and that's just hearings. Do you think this will even go to trial, or do you think we are likely to see some sort of plea deal?
I don't know about a plea deal. I thought, Nichole, about whether some of this was sort of trying to set up a plea deal, that the defense was maybe putting this on the table as something they might argue to try to get a plea deal for less than life in prison. I don't know if the prosecutors are open to a plea discussion. I haven't seen any willingness or any apparent willingness to do this. As for whether or not this is going to trial in September, that state court judge is adamant that this case is going to start jury selection in September. He seems committed to that timing.
And I know we spoke about this earlier this week, but one of your answers, you were talking about how the defense doesn't work federally, that you can maybe use, in a state case. So how much does it complicate things to have both state and federal charges?
Well, it's extremely complicated. We're seeing right now how that plays out because the defense has to not only worry about what's going to happen in state court and what's going to be effective in state court, but then they have to worry about how that state court outcome or what they say in state court is going to impact the federal case. And all of this is compiling. The defense, if he gets convicted, is going to have an appeal that they're going to press, that this whole proceeding was unfair to Mangione, that two prosecutions going on simultaneously with trials scheduled so closely together, and all of the implications of that have made his defense especially difficult. And part of this, I think, is setting up a record for that potential appellate argument.
All right, Richard Schoenstein breaking it all down for us. Thank you.